Hi, and welcome to Collaboration is Key, working with law enforcement. This is part of AEquitas's series on the foundations of sexual violence. AEquitas is really proud to be federally funded to provide you in the field with innovative, informed, and hopefully really practical strategies to improve your response to sexual violence and other crimes such as domestic violence, stalking, and human trafficking. We do that in a number of ways, including recorded trainings and resources that live on our website and are public facing, but we also have a lot of research, case law compilations, statutory compilations, so please check out our website. We also are available to provide training, whether that be virtual or in person, whether that be large scale or small scale, all specifically tailored to your jurisdiction, your needs, and the audience. We're involved in a lot of partnerships and initiatives. One I'll highlight right now, because we're talking about sexual assault prosecutions, is our work with the Sexual Assault Kit Initiative, or the SAKI project, which is helping jurisdictions not only clear their backlog of rape kits that have been untested, but also to refine and reshape their response that led to that happening in the first place. And probably my favorite thing that we do here at AEquitas is offer our services for consultations. And so that can be case specific, where we're working one-on-one to help develop a strategy or provide specific peer-to-peer connections or research that you may need. So you can reach out to us however you want. We've got our website here along with all of our social media handles. So feel free to follow us. Please follow us. We're constantly trying to push out new resources, training opportunities, and that type of thing. This series in particular is being supported by the Office of Violence Against Women. We thank them for their support. However, not everything that John and I say today is necessarily the views of the department. And we're always kind of taking what we learn from the field, that innovative, those informed practices, and pushing them back out to the field. So you'll see sometimes that we have citations or we'll acknowledge the work of others, and we do that under the fair use doctrine. So when we talk about collaboration today, I'm going to have a conversation with my colleague, John Wilkinson. We're both attorney advisors with AEquitas, we love co-presenting together because our experience is sometimes we can really contrast it by the offices we worked in. But then when we talk about these types of topics, we end up realizing that no matter how big the office is, we came across the same similarities and challenges and things like that. So John, if you don't mind introducing yourself.
Hey, Jane, thanks for having me. And yeah, that's so true. It's like, it doesn't matter. It's just the same. I always sort of thought, if you could do these things in Little Fredericksburg, where I was an assistant Commonwealth attorney, which is what we call the prosecutors in Virginia, you could do it anywhere. But in some ways, being from a small office there were only 4 prosecutors when I started, it's kind of easier to do some of these things. And so it might be a misnomer, like you'd say Miami, where you were a prosecutor. Oh, of course they can do it. They have everything. It's a big office.
You've seen CSI Miami, right, John?
Yes,
exactly.
If you don't solve the crime inside an hour with commercials, I don't know.
What are you doing?
Yeah, exactly.
What are you doing?
So anyway, just being from that small jurisdiction, it is different, but it's just funny how it's really the same. These crimes are the same. The tactics are the same. And solutions can vary, but they're often the same. And that what we're going to talk about today, in particular, collaboration. To me, that's the key. And that was my experience in Fredericksburg. Of course, I tried everything from traffic offenses to first-degree murder, because you're in a small jurisdiction. So whatever comes up on your day, that's what you handle. But I did focus a lot on the domestic violence, homicide, sexual violence, and I was on our sexual assault response team. And that kind of opened my eyes to how these crimes are different and they require a different approach. And a big part of that approach is collaboration. And that is the key to solving probably all crime, right? But these crimes in particular, because they are more challenging, people don't understand how these crimes work, not just the people who are going to be the fact finders in the case, but the people who investigate and prosecute them too. And so when you work collaboratively, your education level about these crimes goes through the roof. So that was my favorite part of that.
Yeah. And if you've ever heard AEquitas talk about any topic whatsoever, you will find the common theme is always going to be collaboration.
Right.
But it can look different. I'm glad you brought that up. Of the small community, it might be somewhat easier to collaborate, especially if you're talking like systematic level. Because, as a baby prosecutor in Miami, one of 250 prosecutors, one of 25 prosecutors when I started only doing domestic violence, like I wasn't at the table making systematic big decisions of how we were going to address domestic violence or sexual violence. Later on in my career, I had more opportunities to kind of be at that level. But I think one of the great things about what I foresee our conversation to be is that you can think about collaboration on different levels. So even if you're in an office where you're not making big policy decisions, you can still on your level, in your cases, really implement some of the strategies to build and enhance your collaboration with your law enforcement partners, because we're the closest collaborators in the overall kind of world of collaborative partners. It's like more of a natural intersection.
No, I agree 100%. And, those partnerships, you can't take for granted either. They require, it's a relationship that requires work, like all relationships. And even though we do work closely with police, we see them constantly. In our small jurisdiction, we had maybe a little over 100 sworn. So you kind of knew everybody. That's what makes it a little easier. It's just easy to call somebody and say, hey, what about this? What about that? And same with folks in the community could call anybody and things like that. But those relationships require maintenance and work. And I often had assumptions about what the police did that I thought I knew. And then when I worked closely with them, I was like, oh, I didn't realize you did that because of X, Y, or Z. That makes perfect sense. That enlightens me, even though we work closely together and have for years.
Yeah, absolutely. So we're going to talk about how to identify those opportunities to collaborate and enhance collaboration that might already be happening, how to make it more effective. But also at the same time, on the other side of the coin, thinking about, well, we might share common missions. Even a lot of the way that we do our work might be very well aligned. There's always going to be areas of potential conflict or tension. So how to make sure we're looking at that and addressing it, if possible, before it happens, before you're in the middle of like a big conflict, having conversations about that. And then this collaboration not only makes us do our jobs better, I think it demonstrates to the community, it demonstrates victims that we're taking a holistic approach, and that we've got this sort of collaborative, supportive network of folks that are working on their behalf, and not just like this one person over here and this one person over here. So we do often talk about this common mission, and with that comes, I think, a consistent approach, which is really key, so that everyone who's working together has the same thoughts about how we're doing things. So these are some of the key words that I hear in a lot of, promising practices. You hear a lot of folks being like, okay, well, we're victim centered, we're trauma informed, we're offender focused. But I want to kind of maybe tear these apart a little bit, dive in a little bit deeper and think about, what does this truly mean from the prosecutor's point of view, from the law enforcement's point of view, how those are aligned, maybe how they're not aligned sometimes. And then also, well, we've got another conversation as part of this series about collaborating with victim services. Oftentimes it's all of these pieces working together, and how those happen. So John, I'm going to put you on the spot. I'm going to ask you for your definition of victim centered. What does that mean to you from that prosecution point of view?
So to me, everything we're talking about here is important. The consistent approach, I really do love that that's there, so that wherever a victim intersects the system, they're getting the same appropriate response from wherever that might be. And so that's so important. And of course, that response should be victim-centered. And so for me, being victim-centered is just recognizing that everything we do and every decision we make impacts a victim in a case as a prosecutor. So simple things like, oh, sure, I'm going to agree to that continuance. I've got a busy day anyway, so I'm going to just move that case. Well, how does that impact my victim? Is that a legitimate request for a continuance? How is that going to affect the health of my case down the road? Things like that. I definitely want to think about how it's impacting victims. I also want to make sure that how I interact with victims is a way that victims feel like they can trust me, that they can share with me, they can tell me things. I want to know everything that they know, and I want them to be able to tell that to me. And I want to make sure as I explain things, I'm doing it in a way that they can appreciate or meaningfully access. Because it was just one of my constant things I would see is I would meet with victims with our office advocate, our victim witness person, and I'd go over everything and interview and get information and things like that. And then I'd see them in the hall with the advocate, our office-based advocate, re-explaining exactly what I had just said. And it's just like, I'm trying to be professional and some sort of, I'm not really connecting with this individual. And I'm not being victim-centered. And
Giving them like a civics lesson about the
Yeah.
judicial system.
And so I'm missing good information that they might, if I had built rapport with them in a way that they appreciated what I was trying to do, that I believed them, that I understood how awful this was, what happened to them, that they might be a little better able to share additional information with me. I never interviewed a victim where I didn't learn something new about a case every single time. Not in the police report, not communicated to me from others, things that the police didn't know about. Every single time, I just learned something new. So that when we're not only victim-centered, but trauma-informed, we're going to increase that ability for victims to share more information and better information with us about what happened to them.
And the offender focused, I mean, obviously, we're in the job of holding offenders accountable, but that's not all that offender focused really means. It also means making sure that we're placing the blame where it belongs, and we're reviewing the evidence in the right way. And I think, I mean, obviously this is like a Venn diagram, these things are overlapping, but I think oftentimes as prosecutors, we're on the defensive and we're not being proactive enough to really shine the spotlight on who this offender is and what the offender is doing.
Yeah, and I think that goes across the board for all the players in the system. So again, begins with investigation. I want to be offender focused and focus on what I don't have to make a judgment yet about what happened. It's my job to investigate. I'm just going to investigate what was told and put that focus on the offender. And then as the prosecutor, I'm going to do the same thing. I want to recognize, what is the offender doing? Sometimes these cases are really difficult to try, and the victim makes decisions about how to respond in ways that we may not understand. And so having access to that other partner, victim service personnel, is going to help me there. And so I want to access that. But I want to make sure that I recognize that the victim is responding the way they did because of what the offender did to them. And so that's going to keep me laser focused on getting the bad guy, what the offender did. And then additionally, as you pointed out, it's a strategic consideration at trial that if we're constantly explaining why the victim did what they did or why the victim didn't do what they didn't do, we're not going to have much success. We have to make sure that that judge or jury is focused, and they're almost always juries, at least all of my sexual assault cases were, are focused on what the offender did and why they did what they did. So there might be challenging facts in our case to put the focus on the offender, but we just have to think and understand how these crimes work. The voluntarily intoxicated victim, juries aren't going to like that. They might focus on that fact. Well, focus on it from this perspective. That's why this offender selected that victim, because they were intoxicated, because they were vulnerable. That's not the only way to be vulnerable. There are other vulnerabilities that people take advantage of. Intoxication is one. but that's what we're going to get their focus on. So it's strategic and it's also systematic. We have to be offender focused about everything that we do to make sure that victims are supported the way they should be and that we're able to go forward with our eye on the ball.
Yeah, and I'm thinking that we do that a lot, and we're talking here about the consistent approach that's ideal. Because have you ever read an arrest form or arrest affidavit where you can almost tell that the detective doesn't think the case should go forward?
Yeah. Yeah. So it's just like, because look, if you don't do these cases regularly, then you may not understand how these cases work and how offenders get away with this and why most victims never report these crimes. So a simple delay, continued contact with an offender, that might be something that a law enforcement or officer or a prosecutor who hasn't done these cases may not understand and may sort of make bad decisions based on something that is actually very commonplace. Not every victim does each of those things, but many victims do. And when you work closely with advocacy, you'll better understand it. And so you won't fall into that trap. Because when you do get a report like that, if you don't understand the case, you're immediately, that's going to go in the plea or not going forward pile. And then these are good cases that I'm going to spend my limited time and resources on. But if you do understand how the cases work and you get that police report, then you realize there's a lot more work to be done in this case, and we got to start right away because we're already behind the ball.
Yeah. I was thinking there's some research that came out a while ago. I'm going to do a little sideline here, but basically the idea is that rape myths about sexual assault are pervasive and they affect everybody. They affect, our jurors, they affect our victims, our offenders. They also equally affect prosecutors and law enforcement. We are equally people within our communities that have access to movies and things like that. So on the premise that everyone is affected by rape myths, they started looking at the language used in police reports. And they saw that police reports were containing a lot of these rape myths within them. And then, of course, not a surprise, they followed the life of that case and whether that case was eventually indicted and charged. And not surprisingly, when the rape myths were in the reports, you're less likely to have a prosecutor take it up, less likely to go forward. And just a certain language, you gave the example of voluntary intoxication, a report that says, the victim was drunk versus a report that says the offender continued to buy the victim drinks and then the offender offered a ride home. Like, that's totally framed in different ways. And it could absolutely affect how that case is put forward.
Yeah, no, I think that's 100% true. And it's tough. So you have to really work proactively with the team to make sure everybody is on the same page. And, it's great to have these teams. I love being part of a team because they really do support you. I know we're going to talk about sometimes when prosecutors and law enforcement, have conflict over decision. We have to make decisions. They make decisions. We make decisions. And sometimes we don't agree. But that team is always there for me. So I certainly didn't win every case I tried. When you come out after trying a hard fought case that you lost, there's the team. And we're doing a quick rundown of the case. And law enforcement always said, we're going to get them next time. It's just like that hopeful, that sort of good, we did everything we could, blah, blah, blah. Maybe we're going to evaluate what we did and figure out, could we have done more? If a case like this comes down in the future, what could we have done better? Things like that. So it's great to have that partnership, and those myths are pervasive. That's why, victims are subject to those myths too. And that's why I think a lot of folks never report their victimization because they're blaming themselves for something that was not their fault and they're not to blame for.
Yep. So this is how, we're depicting visually the victim-centered approach. We always kind of talk about the three main legs of this. Well, maybe I am law enforcement, prosecutors, victim services, but there's some other folks in here too that might be part of your response that you want to think about. The main one in sexual assault cases, of course, would be the medical response. So maybe a sane examiner. But you might have situations where a victim should have their own attorney. You'll also have your victim witness counselor that may be distinct from a victim service provider that's located in a community organization. Your victim witness counselor may be out of your office, that's helping keep the victim informed and providing them access and referrals. So all of this and probably lots more, when working together, is demonstrating to the victim this holistic approach. And again, you've got that team that you can rely upon for certain things. So we're going to focus on the law enforcement prosecutor relationship for this conversation, but folks should listen to some of our other parts of this series. We have another conversation about victim services and just generally about strategies to improve our response. So I think we've talked about why this is so important. Most of it is so that John feels better after he loses a case, I think.
That's right.
I'm going to add that here. No.
Yeah.
But here's, some of the things that I'd say. But it does, it's not only good for the victim, but it also benefits you personally as a prosecutor, because then I'm not thinking I have to do a million things.
Right.
I've got someone there that's I can hand the victim off and say, hey, right now I'm prepping this case. Victim, you go get your services. You do this piece of it. And so it's a mutually beneficial situation.
Yeah. Oh, it's 100%. I honestly think it's extra beneficial for the prosecutor. But you'd think the way the team responds to prosecution being involved that they were getting all the benefit, but we definitely get a big chunk of the benefit because victims are sharing things with me that honestly are just like, I don't know what to do. But when I work closely with particularly community-based advocacy, system-based advocacy is phenomenal and a huge, huge help to us. But that community-based advocacy, they can do so many things for you that just take it off my plate. And they're just like, oh, I know actually what to tell you now because I work with these folks and I know they can help you with this. So I'm going to connect you with somebody instead of saying something silly like, well, maybe you should call social services, or you could call the house. Yeah, here's a brochure. And those things are good. I don't want to minimize that because they can be helpful. But to actually be able to give somebody help that is going to work and work right away, and it's going to work, is super supportive of victims and supportive of what we're trying to do. So that collaborative approach is great in the support. And when the victims get that support, at least in my experience, not every victim took advantage of advocacy. And the ones that did, I just always found that they became stronger witnesses and I ended up with a stronger case because they got that support that they needed related to their victimization that we don't typically provide, right? They have to get it elsewhere. We can be part of that and we can learn from that support that is given, and so that our approach is improved and better. But it just made a stronger case for me. The other thing, the system response, that it's consistent and that we work together. My experience was that the community-based advocacy would go to bat for me with a victim, and because they had worked with me and they now trusted me, and so they could tell, hey, do you want to share that with Mr. Wilkinson, what we talked about? And it was usually information that was important to the case, that it was a good thing that I learned. But having that relationship with them and the system response, we improved trust across the board, and I was able to get more and better information, and that helped us achieve justice. The one big one that I always include, and this could be related to me not losing cases, but that support, but was the education that I got from the collaboration. I also shared information too about why I do some of the things that I have to do, like discovery obligations and sharing information that could potentially be exculpatory or mitigate the defendant's sentence for whatever reason. And so sharing that with the advocacy and the others on the team is important, because they might say, you know, hey, she's very worried about you sharing that information. Do we have to do that right away? Well, I have to do it by X date, and I do want to do it sooner rather than later, but is there something safety planning we want to engage in before I turn that over? So now's the opportunity, and I can, you know, wait a couple days and then I'll turn it over. Things like that, them learning about what we're doing and me really learning about what they can do and how these crimes work, both from advocacy and experienced law enforcement. Has been fantastic for me. I often, law enforcement would provide me, just by working closely and talking over the case, provide me with the theme of my case. They'd say something, they'd point out a fact that I was just like, boom, that's it. That's what I'm going to hammer away at. That's the theme of my case.
Yeah, because no matter how well they write a report, they have more knowledge of that case in their heads than they could ever put into that report.
Yeah.
And they'll have these little observations, like they'll know for sure if the defendant's going to testify or not. They
Right.
always were the best predictor of that, because
Yeah.
they were like, this guy, he's going to want to take the stand. They would say things like that to me. I would ask them, what do you think the defense is going to be? And law enforcement was always really great. And I think they enjoyed that collaborative approach. So it wasn't like, okay, your job is from point A to point B. My job is from point B to point C. And having that collaboration and overlap, soundboarding, like what else could we get to corroborate this case? Like, have we thought about X? Have we done this? That collaboration was really key to me. And the communication also good, because, you know, victims don't necessarily know who to call when, right? It's great to build a collaborative response. So they're like, okay, my point person is this person, and then it goes from there. But I'd often have prosecutors call me because it was something court related, but then they maybe call the detective. And to put a pin on that, like system response, if it was very obvious that the left hand didn't know what the right hand was doing, it was so disheartening to that victim.
Yeah.
It really was the opposite of what we'd want to do, right? It demonstrated to them, like, we're all working in silos, and like there isn't the systematic response. And that speaks really loudly as well. When, you know, they call the detective and the detective's like, oh, I don't know, was that case charged? I don't know, is that case going to trial? And like, no, there's no communication. So that can be really key as well.
That's another great point, just about, you know, the SART, the sexual assault response team, is the institutionalizing of that collaboration. You don't have to have a SART. You can do that regular meetings. We used to, you know, detectives would come by and talk about cases. You might be on call, things like that. But that when it's institutionalized, we were a small jurisdiction, so it wasn't as big a deal, but you knew somebody that you could call. So a detective could just call and say, oh, John and I have worked these cases, or John's on the SART and we talked about this case. I need help with X, Y, or Z strategy, or a search warrant. Do I have enough, or whatever it might be? And so it's just, there's all sorts of benefits from that regular collaboration that's institutionalized in a SART. You don't have a SART, you can still do all of these things. You just do them in a more piecemeal way.
Yeah, because the cases are going to come. I mean, I worked in Miami, obviously, 47 different police departments. And so I obviously didn't know the names of everyone, but there were certain, you know, there were 10 major jurisdictions. There were the SVU units in those jurisdictions. So I was eventually getting to know, okay, these are the guys that are, these are the men and women that are actually investigating these cases. And you know what they're going to look like based on who's investigating the case. But I found that you could collaborate on that case to case level as well. And oftentimes just having an interest and demonstrating that you're willing to go the extra mile. I often would get law enforcement to come with me. If I had somebody that, because, hey, this is hard work and there's a certain level of burnout, and you may be working in a jurisdiction that has historically not been successful in these cases. And that lack of success can sometimes lead to well, then why are we trying this hard? Like, this is going to be a he said, she said case. So I'm going to write this up and, it's going to go its way. And that can be really easy to kind of get into. But if I had like a go-getter detective that was like, hey, I've got this case, this guy is a bad guy. I want to go get the surveillance video. I want to do this. And I'd be like, I'll help you write the search warrant. Let's get this done. Then it would build up like a stronger response. And then the success also begets success when you start trying new strategies together and it's a team. You're going to have, yeah.
And then they share those stories with other folks that they're working with. And then you're getting calls from other people, I was like, that's not my case. I don't know. It's like, yeah, but I heard, and now can you help me with it? And it's just like, yeah, that's great. It's just like a great way to build capacity and share expertise and knowledge and experience. Not even expertise. It's sometimes it's trial, try and fail, try and succeed. You try different things. They don't all work, but some of them do. And we move the ball forward.
Yeah. So there's key ways that we can collaborate, and we've kind of picked up on a couple of them. There is this like more natural intersection. I mean, depending on where you work. I've definitely, we work with folks all around the country, and there's variations of this. Everything from, the law enforcement does all the work and just hands something to the prosecutor, and the prosecutor takes it from there. And there's like very little kind of collaboration to the other side, which is, okay, law enforcement gets an investigation, and the first thing they're doing is calling the prosecutor to be like, hey, I've got this investigation, let's collaborate on this. And like every variation in between.
Mm-hmm.
So I think that investigative piece, like how soon prosecutors get brought into that, or if they get brought into that, I think that's one of the most natural ways I can think about how collaboration works. Do you have other examples? I think I love the trial prep with law enforcement.
Yeah. So of course you're going to collaborate there. And, depending on the size of your case, again, we were a smaller jurisdiction, so you kind of already knew all the officers and the detectives. And so for the bigger cases, you're working much more closely, and it's a great process. So, I mean, we do have lots of those opportunities for collaboration. I do like when it's institutionalized, so it's just a regular thing, and it's just even that. I just remember the first meeting, because we started the SART when I was there, and I was like the first member of the SART from the prosecutor's office, and just what an awkward thing it was. It's just like, I don't know what we're doing. I don't know what this is, and I'm in charge. And so here we go. But you just quickly, just like people get, all right, we're just going to talk about it. And then you just quickly, and then over time, we're meeting once a month. And now we're just regularly talking about those things. And that gives the opportunity for people for an aside, like, hey, I think we could do a better job in this area if we did, blah, blah, blah. I was like, oh, that's interesting. And, and now I trust you and I know you. So we do have those opportunities institutionalized to collaborate. And of course, then there's going to be those times where we're not going the same direction, where we do conflict. Yeah. And if you have that institutionalized communication, that regular, I think that goes a long way, because often to me, it is just an element of communication. And I feel like there have been opportunities to explain the decision I was making and why I was making it that law enforcement didn't agree with, but I didn't take that opportunity, or I didn't take it, use it to the best of my ability. I didn't fully explain why we were doing it. And
so where did you see these common areas usually? I think you're getting like charging decisions.
Yeah, so in our jurisdiction, the police did the bulk of the charging decisions, but we still decided whether we would go forward with the case or not. And we also did charging decisions in more limited circumstances. But it would be whether you're going to go forward with the case, or at what level that case would be go forward, or in a plea agreement on a case. So those are common areas where, when I wasn't on the same page with the investigator, that conflict arose. when we were working closely and on the same page, we were usually arriving, at the same decision point, even when they charged a case, because in our system, at least the way our CERT worked, it was based on those cases that we had in the prosecutor's office. So those were all charged cases. We'd talk them over. And so as we go through them, we realize this needs some work, this we're going to have an issue with. They did a really good job. So I wouldn't say that it was mostly cases that had deficiencies, but there were often cases that I just felt like I cannot make this element. I cannot go forward. So you just had a lot of that going on, or how we would resolve that case. And I would make a point to talk with law enforcement about it, as well as the victim. Particularly if you're declining a case with an identified victim that law enforcement has referred to you. It wasn't always a referral. Law enforcement would often call me, bring by the report, we'd talk it over, and they hadn't arrested because they had questions about it. And then, we're on the same page, but I don't want to have conflict with a victim who has reported a crime. And so our system-based advocate made a point of saying, look, I'm going to contact the victim and have them come in so you can explain your decision not to go forward, which I of course, initially, Jane knows me well, was like, do we have to meet? Couldn't we send a letter or something? She's like, no, it's a big
Conflict averse.
It's a big decision. And so we'd have those meetings too. So, but with the law enforcement, it's really open communication. And as you collaborate together, they also have trust in your judgment as well over time as you work together. If you're brand new and I'm not doing that, and they don't know you, that's not a good way to start. Not that you should try a case that you don't think you can go forward with, but you've got to have that communication and collaboration so that you avoid that kind of conflict that's not good for the team or the victim or the cases that are coming out of your system. There are going to be conflicts from time to time. People don't always agree. So those are ways to hopefully avoid that.
Yeah, and I think if you can have that communication, like before something happens, like even if it's a little cross training where prosecutors come in and talk about, okay, what is my charging standard? Because it's not probable cause. That's typically what the arrest standard is, but that's not going to be my standard. And I know, we don't really work in places where law enforcement is arresting purely on probable cause without, thinking like, I know the prosecutor's not going to go forward. I mean, we're having these conversations, but sometimes it's good to sort of ground it again and be like, hey, our office policy, our ethical standard is this per ABA rules, but our office, how we articulate our charging standard is this. And that usually is something office specific. And then you could have that conversation before you're in the middle of one case that is, where you're butting heads.
Yeah, I think that really comes in to play in those cases where the investigation, he did it, but there is something about the case that we can't prove. There's some element or there's some impediment to our ability to improve that case. There's a piece of evidence that is not going to be admissible, a statement or a confession by the defendant. Something is problematic. And when the guy did it, that's where it becomes potential conflict. So again, just our guys did such a good job that it didn't happen all the time, but it happens, and it happens regularly, and it happens around those areas. And so I think what you said earlier is you can prepare for these issues in a way that is going to be productive, and identify those things, and having opportunities for team members to present like issues that, hey, we're concerned about this aspect of how you're approaching these cases in the prosecution. It is good. I just think it's good. You might not want to listen to everything they have to say, but it might be something that you can explain. Oh, well, that's interesting because this is why we do that.
Yeah. We had a couple of things I'm thinking about as we're talking, where we had to have a conversation because we were getting feedback from the jury in cases that they did not like how law enforcement was recording the offender interviews. So they had a policy where they spoke to the offender off without it being recorded. They had a conversation. And then if they got a statement, then they would say, okay, we're now going to record your statement. And they would press record, and then they'd have this condensed, very short statement. And there was lots of reasons why they did that. One is I didn't have to listen to the 4 hours of, them building rapport with the defendant. They felt there was a chilling effect there were legitimate reasons for this practice. But what happened was we got these recordings where the law enforcement officer was often referring back to their previous conversation and be like, hey, remember when you told me X? And then trying to prompt them to say it on the recording. And so the juries hated it. They hated it. And then, of course, law enforcement had a hard time articulating why they did this. They were just like, this is our policy. This is our policy. And that became the juries hate that.
Yes.
So we had to have a bigger conversation about, okay, why do we have this policy? There are legitimate reasons to have this policy. So if you're going to keep the policy, we would prefer you not to, but if you're going to keep this policy, then everyone needs to be trained to articulate why you have the policy.
Yeah.
Because it's our policy is not going to work.
Yes. And then you don't have that's a field day for the defense too.
Oh my gosh, John.
Just you didn't record everything he said, just the things that you liked. Yeah.
So that was problematic. And it came from prosecutors because, that's always how it was done. So I didn't really think too much of it because that was just always how it was done. But juries were coming back and were saying, this is what we didn't like about this case. And so it was coming from the prosecutor, and we had to have that conversation. And eventually they did change their policy about that. So that was another thing that just kind of popped up in my head, a potential, how you're going about something.
Yeah, I think one of ours was the initial response in sexual violence cases that patrol was doing way more than we wanted them to do. And so the protocol, because they're not trying to do anything bad. They're really doing their job, and they're trying to be detectives when they're not yet detectives, and they maybe don't understand how these crimes work. And so now they're clearly not believing a victim, and we don't need them to make a decision in the first 10 minutes of their interaction with someone who was either just raped or just raped within the last several days or something. So we just had to create a protocol that just said, as soon as you respond to a sexual assault case, you call the on-call detective, who wasn't always the experienced rape detective, but was an experienced detective. So that became the protocol. And then we had to train to it because first responders were used to doing their response like they would in most crimes, which was good for most crimes, but it wasn't good for these crimes. And so you had to make sure, because a few guys were go-getters and they wanted to do that extra mile. And it just, in these crimes, it wasn't always helpful.
Yeah. And I think the follow-up, which is if you are asking law enforcement, either a particular officer or an agency, to change policy, change what they're doing, or to do something extra for you, the most effective way to do that is then to say, okay, then we will back you up by providing this training. We will back you up by, giving training on how you might want to articulate this to a jury, so that people had some sense of, okay, because we have a bunch of cases where we did this policy. So now let's make sure everyone who's testifying is prepared and not put on the spot and feels like they can comfortably articulate the why behind the policy. So when you demonstrate, I'm willing to go the extra mile too. I'm not just asking you to do everything. We're going to be there with you. That goes a long way.
Yeah.
So I think the identifying of the opportunities, one of the things that was really helpful to me, and I did way later in my career than I should have, was how to map how a case went. I didn't know there's a difference if somebody's reporting calling 911 and patrol coming out, like you said, versus maybe going to the hospital and how the case comes from that, or someone delayed reporting, going to a police station to report it, and how cases are assigned. And that is something that, again, reach out to law enforcement and say, hey, maybe we can just do a real basic training where you guys walk me through how this looks from your perspective. When am I getting this kind of report versus this kind of report? Why in some cases I'm getting this and not that? Like, just the really basics that I think sometimes we're like almost embarrassed because we feel like we should know that, but we don't. Like, we never received training about like how things work in a police department.
Yeah. No, I think that is such a valuable exercise, and to make it as multidisciplinary as possible, because as you start to do the map, that's where people start saying, well, wait a minute, sometimes X, sometimes people do this, sometimes people intersect the system with their personal doctor. They don't report to anywhere else. Is there a way we can reach out to that group? They tell a teacher. What about the victim who intersects the system at jury selection? They never have revealed to anyone that they were a victim of sexual assault, and they get asked in a sexual assault trial, jury selection, is there anyone here who has been a victim of sexual assault? And then they don't end up on that jury, and we send them home, and they intersected the system, and we're doing nothing for that victim. Doesn't mean we're going to investigate and try that case, but there's still things we can do to help that individual with what happened to them. And maybe it is a case that ends up there is evidence or something, but it's just, where could anyone intersect this system, and do we have a response that's consistent in that area?
Yeah, that's awesome. And then you'll also identify gaps. I think it's a great way, especially if you're just starting out a response or you're just trying to build something, to start with, okay, let's get down to the basics. Because I think about how I would explain a case going through the prosecutor's office, and it would be hard for me to do that because there's so many like choose your own adventure kind of things. And then thinking about, okay, now that we've mapped that out, where are all these opportunities where we can be collaborating better?
Yeah.
How can we do that before the case, during the case, and I think also I want to say after the case. So we have a couple here, and I think we've talked about some of them, but do you have on-call prosecutors assigned so that detectives, patrol officers that are doing the work that come about a case, can they call you? Or someone that we literally had beeper duty, or we had a beeper until 2014.
Oh, that's a little longer than necessary.
A little longer. I don't think they would break, and like we couldn't even fix them.
Right.
So this idea of like having someone on call, I love the idea of having a specialized prosecutor on call, so that you're not just getting, any prosecutor, but you're getting somebody with, so we would have an on-call for homicides, an on-call for robbery, an on-call for domestic, and on-call for sexual violence, and probably a couple of others. And so that's a great way to start that collaboration immediately upon, a potential case coming.
Yeah, I'm nodding my head, although it's almost pitch dark here.
Yeah, where are you?
I look like I'm at a campfire, but it's just, I only have the one light going, and
then I'm like the sun.
Yeah. I'm on the East Coast. You are not.
I'm in Mississippi.
Yeah, so I like that intersection. The task force one is the one that I had. So even if you had an on-call prosecutor, because I worked with detectives through the task force, they would not necessarily call the on-call. They would call me because they already know me. It just makes things easier, and it shortcuts the scenarios, because we've already probably talked about most of these scenarios. I got this scenario, instead of having to explain to someone you've never met before or don't know well, okay, blah, 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 and go on and on to get to the ultimate question. You've already sort of know how to communicate with each other.
Yeah. And this is different. This is why it's so important to map it out for you guys personally, wherever you're working, because it's going to look different. In Florida, we conducted pre-file interviews. So even if somebody is arrested, before I file an information, which is how we charged cases in Miami. Before I did that, made my charging decision, I had 21 days to take sworn statements from all witnesses, including law enforcement, including victims. And so often that was an opportunity for me to say, okay, what's not in your report? I have your report, but what else should I know? What else is going on? So that was an opportunity very early on for me to intersect and get to know that law enforcement, exchange cell phone numbers so they didn't have to, call my beeper. Let them know like, hey, you can contact me anytime. If the victim reaches out to you, feel free to share my information. So that was a really good opportunity for me to start collaborating early on a case by case basis. And then of course, the same detective started going into the pre-file interviews, and then we had these relationships that were already built.
So, which is a great opportunity. Some jurisdictions have a charging unit, and so it might be folks that don't actually try those cases. They're just reviewing them for charge. So that might be an opportunity to train the charging unit about the particularities of these cases so that they are on top of how victims respond to this and good credibility judgments and what else might be needed if you're in a jurisdiction that's going to say, look, I think we need more here, and here's what I think we need.
That's a really great call there. Reviewing discovery, making sure we're up to date with Brady disclosures. That's obviously it's going to be impugned to us. Is that the right word? We're going to be considered to know everything the law enforcement.
Exactly. I knew what you meant.
So we better be sure we know what's in their file, right? The last thing is like, oh, by the way, I have this lineup. So that's a good opportunity to say, hey, we're finishing our discovery. This is the time period. I've got to make sure I've got everything going. We're going to trial. Bring in your file. Let's go sit down together, make sure I have everything you have. That's a great opportunity to, again, collaborate.
And just the things that, we know are routine that we maybe haven't gone out of our way to share with law enforcement. Like particularly if you ever had a case with a victim, a woman in prostitution who was a victim of sexual assault, and law enforcement might know this person from the community and have interacted with them many times. And on this particular occasion, maybe they're like, look, let me just buy you a hamburger and soda while we're talking, just something simple that they did. But do they know that we kind of need to know that, and we have to turn it over? And just anything that we do that works a benefit to that person. Maybe it's we're not going to charge this case, or I'm not going to arrest you for this offense. I'll talk to the prosecutor about whatever it is. We want to make sure we're all on the same page on that too.
And like you said, there's never a victim interview that you didn't learn something new. I don't think I ever met with law enforcement where I didn't learn something new.
You're right.
Like going into property together, sometimes I'd have like property receipts and it would just be like personal items. And that's how it'd be listed on my property receipt. And I'd be like, let's go and look at everything before we go to trial. And all of a sudden I'm looking at stuff and I'm like, oh my gosh, there's all this stuff that that we could do. So communication on case updates is so key. Just like victims are like, is the trial coming? Letting them know why there are delays, letting them know the likelihood of trial versus plea so that they can prepare themselves. That's great. Of course, if we're asking them to do any follow-up investigation, because we want to maybe make the case stronger, or maybe there's some evidence of witness tampering or intimidation or ongoing, or maybe there's like some 404B evidence, we want them to go track down additional witnesses or reports from an out-of-state kind of case.
Right.
That's always going to be better if we have a relationship where they know we're asking them to do this, not because we just want to make them do stuff, but we're making the case stronger, and that we're building this case together. And I'm going to be working extra hard too. But I also am going to ask you to work these extra steps.
Yeah, and it often comes from that victim interview that we do, where we learn the new thing.
Yeah, they stopped at the ATM on the way home.
Yeah, it's like, oh, did you mention that to anyone? No, I just remembered it now. Okay, blah blah blah. Not, and then being trauma informed is all part of it, and how we ask that question. we're getting more information because we're trauma informed at every stage. And so it's not surprising that we get piecemeal disclosures, and could be an important detail that's shared with us that wasn't shared with law enforcement, but that requires some corroboration.
Yeah. Safety planning, law enforcement can be a key partner in that. I usually, we rely on our victim service professionals to do a lot of that safety planning, but it could include an opportunity for law enforcement to be involved on a safety planning issue, especially if we have that evidence of intimidation or tampering.
Yeah. And, they're in a relationship with that victim too. And that they often pick up on things that maybe we're not picking up on. And just like, look, I think she's really afraid to stay on campus. Do you think there's any way we could, and it's like, oh, well, let's talk to, the university. Is there some off-campus resource? Or let's talk to our advocacy because they may have a housing assistance and just simple things.
And you make a good point. Sometimes, we have a point person where we've given them victim services, but they have connected with that detective, that first person that believed them, the first person they interacted with, and they're going to be their go-to person following up their first call. And that might just be the way that this case works.
Yeah.
And so they're going to be maybe the person that has that little update, which is like, hey, I got this Facebook message. I didn't really want to call the prosecutor and bother her, but blah, blah, blah. So that's key. Pre-trial interviews. Sometimes I think we minimize the fact, we're prioritizing pre-trial interviews of our victim, and we don't give the right amount of time to the law enforcement. And then during that pre-trial interview, asking those questions to think about trial strategies and themes. And I feel like I like to put on my detective hat sometimes and be like, I really should have just been a detective, saved myself some law school debt. But I think a lot of detectives also kind of want to put on their lawyer hat sometimes. And have fun with like, ooh, let's come up with a cool theme for this case.
Yeah. No, and I think both of those, the pretrial interview, I just think you made a great point about that, is that, my assumption is you're a professional, you know how to testify, but let's spend time going over it, because it's not just, it's another situation where we silo ourselves, and the detective may remember a key piece or talk about something that is important to them that I have not. And I was like, oh, that's right, that is important. And just like, let's be prepared on that. It's also just a great way for them to get prepared for trial that's coming up in the next day or so. And as you said, creating our trial strategy and mapping how we're going to get from incident to guilty.
And let them know like what was admitted, or maybe something that was that has been ruled to be inadmissible, and to give them a heads up like, hey, you cannot mention this, or
Right.
There was a CODIS hit, but we're going to call it an investigative lead. We're not going to bring in the fact, like there's some like magic words that we prosecutors and special ways that we phrase things like, is this a fair and accurate representation of?
Right.
Like, some of that one, I'm guessing most of the detectives, if they've ever testified, probably have. But sometimes I feel like we assume that they're going to know that we're, I've got to establish venue, and they're just like, why are you asking me this?
And not every detective testifies all the time, or with the frequency that some do, or have a history of doing it. And so you do spend time just prepping. I think it's a great idea.
And then the last one here I have is like case review or debrief. And again, this can be institutionalized and formalized. But I always thought, well, trial's over, we got our verdict. We're usually either way the verdict went, we're probably grabbing beers.
Yes.
Or like something. This is the part that OVW is not in line with. But but there's usually some amount, but sometimes it's just like, oh my God, that's over, and I have to go on to my next thing. And we're not really thoughtful about, let's have an intentional conversation about what went well, what maybe didn't go so well, why we thought we were really successful this time. What I think we did differently that really worked here was we did X, Y, and Z.
Yeah.
And this one, I think they struggled with this. Probably next time, maybe we need to bring in an expert.
Yeah.
And we don't give ourselves that time sometimes. But did you guys do that in your SART? Did you ever do like, sometimes it's named like a case
like a
not
hot wash, we would call it, or the military calls it a hot wash. We would just review the case. Yeah, we would do that. And sometimes it would just be, as you said, it depends. Like if a case ends at like midnight, yeah, we're not doing it, or 10 p.m. or something like that. But we would make a point of going back to that case, and cases that ended in the middle of the day. But we would analyze the not guilties, but not think about the guilty verdicts. And I think you made a great point about that, that just do them all, because we can replicate success, and identify those things that that went well. And sometimes, like I had a case where an officer apologized for his testimony because he got emotional on the stand recounting the investigation and what it was a really awful case. And I was just like, are you kidding? That was gold. It was like the jury was like right there with you as you recounted coming on this scene and seeing this horribly beaten victim, and what you did. And I was just like, he thinks he made a terrible mistake. We got a guilty verdict in that case. I'm not just because of how he testified, but he did a good job on the case. But he thought that was a bad thing. I was like, don't ever apologize for that. That worked, worked out well.
And we all like feedback, right? Especially if
Yeah.
they're not used to testifying. They want to hear like, oh, what did I, what can I improve? What can I've testified as a witness in unrelated cases. And the first thing I want to do is I want to talk about like what happened, So I think giving that opportunity is such a great way to build the rapport with your investigators, to build that trust, to build that relationship. So all of those are possible intersections. There's probably more we didn't get to, but I think
the one that I know was a gap in our system was the cases that I wasn't aware of. And can we intersect about those cases that no arrest was made, like in your jurisdiction, no arrest or charge was made in my jurisdiction for whatever reason, that case was not referred for prosecution or did not end up in an arrest. I just didn't know anything about those cases. And I thought we could be more intentional and proactive about, hey, let's figure out what's going on, because if there's some systemic issue related to these cases not going forward, let's figure it out.
Yeah, like have they stopped referring any alcohol facilitated sexual assault because they think the prosecutor's office will never charge them?
Yeah, and that might be based on the prosecutor's office unwritten policy or just things that happen. So yeah, there's definitely that response to how prosecutors handle their cases by law enforcement, and it's not an unsensible, it's a reasonable response, but we want to make sure things like that aren't happening, that everybody is brought to bear on these cases that are tougher, that don't end up getting charged.
And that's a great way to kind of bookend when we talked about the sexual assault kit initiative, is when the funding came down to test the kits, the other part of the funding was, you're not just getting this money to test your kits and go home. You also have to then go look at your policies that led to systematically not testing kits. And they had to go back and say, okay, why are these cases not going forward? And they found common themes. Alcohol involved was one of the big common themes. Just not having good contact information. Victims that were involved in prostitution or commercial sex was another one. And there were some racial disparities as well. So, and that Saki project kind of forced people to go back and take that lens on the cases that weren't going forward and not even getting to a prosecutor's office. But I think there's a way for you to be thoughtful and do that even without that kind of, requirement for your funding.
Yeah.
To back and say, what aren't we seeing? Like, what are we seeing trends that we can then close that gap on?
The other resource that, as you're talking, that I think about is from the Sexual Assault Justice Initiative, the Model Response for Sexual Violence for Prosecutors, RSVP model, that can really help not just prosecutors, but the team and the system that you're working in, so that you're making sure you're evaluating everything that you do, and making sure that it is an adequate response.
So John, I think you and I could talk about this all day.
I know.
So, the going forward piece really is, because even when I was putting this together, I was thinking, well, if you're like a line prosecutor, like you don't have a lot of opportunities to change how collaboration works. Because I was thinking, like, if there's no SART in my jurisdiction and I'm a little baby prosecutor, I'm not starting a SART. So I don't know what I can learn from John. But once we started mapping it out, we came up with dozen of ways that just any prosecutor could enhance collaboration, and to do it early and often. And then those case reviews to not only get to the challenges and think together about maybe strategies, but also identify those promising practices and the good things, so that you can also leverage that. And then, working with law enforcement to actually bring in their expertise. I thought that was really effective when I started bringing them into more of that trial prep and more of the strategy sessions that I would do preparing for these cases. So those are our going forward slides. Lots of resources. John mentioned at the end, AEquitas's model response to sexual violence. There are 2 volumes, I guess, but I really encourage you guys to check those out. They're kind of an A to Z, what you need to know about sexual violence and promising practices, but also kind of talks about how to go and reflect upon maybe your offices. So if you're in a role where you are able to say, okay, let's look at this from 30,000 feet. What are some things that we can do to build more systematic responses? And then John, you've got a resource out here on the use of body cams and how you might have different policies and procedures related to crimes against women and sexual assault. And so we've got a couple of resources there, but honestly, our website is just chock full of things that really do deeper dives into some of the conversations John and I were having today. Want to also shout out to our AEquitas office hours. So these occur the 3rd Thursday of every month from 2 to 4 Eastern time. You can register at our website under the trainings tab, but there's just an opportunity to talk with other prosecutors that are doing this really challenging work across the country. Sometimes that helps you identify emerging trends, new and novel defenses that people are seeing, or defense experts, or really just having an opportunity to soundboard with your colleagues. And so every office hours, they kind of pick a different topic. So this is me. I want to thank everybody for listening in. John, I really want to thank you for having this conversation with me. And I hope you can turn your lights on soon.
Yeah, if that light bulb goes out, I'm in big trouble. Thanks, Jane. This is great, as always.
Yeah, bye.
Bye.